Leading Case 16. Pradeep Kumar Biswas and Ors v. Indian Institute of Chemical Biology and Ors. In this video, we delve into the significant case of Pradeep Kumar Biswas and Ors v. Indian Institute of Chemical Biology and Ors, a landmark ruling that sheds light on the importance of institutional accountability and judicial review in the Indian legal system. This case brief provides valuable litigation insights, exploring the legal relevance and principles that govern the Supreme Court's decision. By examining the plaintiff's rights and defendant's obligations, we gain a deeper understanding of the legal interpretation and case analysis that led to the court's ruling. This case study serves as a crucial precedent, offering valuable lessons for those involved in biological research and chemical biology, highlighting the significance of legal case studies in shaping the Indian law landscape. Tune in to gain a comprehensive understanding of this pivotal case and its lasting impact on the High Court's approach to judicial review and legal principles. Hi, I am Advocate Dr. Saurabh Kapoor, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly subscribe and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family and social groups to spread this knowledge. Chief Justice S.P. Bharucha, Justice Syed Shah Mohammed Quadri, Justice R.C. Lahoti, Justice N. Santosh Hegde, Justice Doraiswamy Raju, Justice Ruma Pal and Justice R.E.G. Pasiat. Introduction. The case of A. Pradeep Kumar Biswas and Ors v. Indian Institute of Chemical Biology and Ors dealt with the question of whether the Council of Scientific and Industrial Research is considered a state under Article 12 of the Indian Constitution. 2. Reconsideration of Subhajit Tweri case. The court reconsidered the case of Subhajit Tweri and found that the decision was erroneous. It was held that the CSR is a state within the meaning of Article 12 of the Constitution. 3. Tests for determining state status. The CSR falls within the range of Article 12 when judged by the tests formulated in A.J. Bosch's case. The question in each case is whether the body is financially, functionally, and administratively dominated by the government. Control must be particular to the body and pervasive. Regulatory control does not make the body a state. 4. Correcting erroneous precedents. A long-standing precedent should not be upheld if it is found to be erroneous and cannot be reconciled with subsequent decisions. The court has a duty to correct its mistakes. The interpretation of state and authority. The definition in Article 12 of the Constitution is not exhaustive and is obvious. The words state and authority in Article 12 are still being interpreted by the courts. Vi. Notification confirming CSR as state. The notification bringing CSR within the scope of the Administrative Tribunals Act confirmed that CSR was considered a state under Article 12. This meant that employees of CSR could bring their service disputes to the administrative tribunals instead of the High Court. 7. Distinction between instrumentalities/agency and other authorities. The principles for determining if a body is the state remain the same, but the emphasis on how they apply to specific facts is different. It's important to differentiate between an instrumentality or agency of the state and an authority included in other authorities. This distinction cannot be erased. An authority must be sui juris to fall within the meaning of other authorities under Article 12. A juridical entity may also be an instrumentality or agency of the state, but not vice versa. 8. Criteria for authority under Article 12. The entity must be created by a statute, have power to make laws or issue binding directions, and be of public importance to be considered an authority under Article 12. 9. Tests for instrumentality/agency of the state. The question of whether an entity is an authority cannot be determined by applying A.J. Bosch tests. The tests are relevant for determining if an entity is an instrumentality or agency of the state, but not all tests need to be positive to qualify. The real source of governing power must be identified, and the entity must have deep and pervasive government control to be considered a state instrumentality or agency. X scope of other authorities under Article 12. The framers of the Constitution use the word the state in a wider sense than usual, including other authorities as long as they are within the territory of India or under the control of the Government of India. The expression under the control of the Government of India in Article 12 qualifies other authorities. 11. Limitations on expanding state doctrine. Expanding the state doctrine through judicial wisdom should be accompanied by wise limitations to prevent overreach. Agency of the state, but not vice versa. 8. Criteria for authority under Article 12. The entity must be created by a statute, have power to make laws or issue binding directions, and be of public importance to be considered an authority under Article 12. 9. Tests for instrumentality/agency of the state. The question of whether an entity is an authority cannot be determined by applying A.J. tests. The tests are relevant for determining if an entity is an instrumentality or agency of the state, but not all tests need to be positive to qualify. The real source of governing power must be identified, and the entity must have deep and pervasive government control to be considered a state instrumentality or agency. Scope of other authorities under Article 12. The framers of the Constitution used the word the state in a wider sense than usual, including other authorities as long as they are within the territory of India or under the control of the Government of India. The expression under the control of the Government of India in Article 12 qualifies other authorities. 11. Limitations on expanding state doctrine. Expanding the state doctrine through judicial wisdom should be accompanied by wise limitations to prevent overreach. 12. Expansion and limitations of Article 12. The definition of the state in Article 12 has been expanded to include various instrumentalities and agencies performing state functions. The limitations and expansion of Article 12 must be determined based on constitutional jurisprudence. 13. Instrumentalities and agencies subject to constitutional limitations. The state can set up instrumentalities or agencies that are subject to the same limitations as the state itself. This was affirmed in several Supreme Court cases. Subhajit Twary, a stenographer with the Council of Scientific and Industrial Research, filed a writ petition for parity of remuneration, but the court denied the application, stating that CSR was not an authority within the meaning of Article 12 of the Constitution. This decision is now being reconsidered. 14. Reconsideration of state definition in Article 12. The court reversed a decision after considering the definition of state in Article 12 and the importance of Article 12 in ensuring constitutional protection of individual rights against the state. The decisions on this matter have expressed both narrow and liberal views. 15. Widening of right to equality through judicial interpretation. Benjamin Cardozo's The Nature of the Judicial Process discusses the widening of the right to equality through judicial interpretation. This includes protection against arbitrary or irrational acts of the state. It also addresses the curbing of arbitrary exercise of power by centers of power. 16. Evolution of state definition. The definition of state was initially limited to authorities or those with similar powers mentioned in the definition of Article 12. But it later came to be understood with reference to the available remedies against it. For example, a statutory corporation with regulations framed by such corporation pursuant to statutory powers was considered a state. The court decided that the expression other authorities in Article 12 includes all constitutional or statutory authorities with powers conferred by law, even if some of those powers are for commercial activities. 17. Expansion of state concept. Impraga Tools Corporation v. Emmanuel/3 SCR 773, the case held that an application for a writ of mandamus could not be brought against a company for enforcement of statutory or public duty. In 1975, the concept of state in Article 12 was redefined to include public authorities with statutory duties for the benefit of the public. 3 SCR 773 and 3 SCR 619-18. Indicia for identifying state agency or instrumentality. Matthew J. in his concurring judgment in Sukhdev Singh v. Bhagatram Sardar Singh Raghuvanshi 3 SCR 619 propounded 4 indicia for identifying an agency or instrumentality of the state, a finding of the state financial support plus an unusual degree of control over the management and policies might lead one to characterize an operation as state action. 19. Subhajit Twary case in CSR. In Subhajit Twary, the court dismissed the writ petition, holding that CSR is not an authority within the meaning of Article 12 of the Constitution. The court noted that CSR does not have a statutory character like other corporations and is a society incorporated under the Societies Registration Act. The court also relied on cases holding that employees of companies incorporated under the Companies Act do not enjoy the protection available to government servants under Article 311. However, the court in the present case found that both premises were not relevant and contrary to the voice and hands approach in Sukhdev Singh. 20. Overruling Subhajit Twary. The court held that Subhajit Twary should not stand as an authority merely because it has stood for 25 years. A new fact relating to CSR has come to light since the decision in Subhajit Twary, which vindicates the conclusion reached and fortifies the decision to deliver the final blow to the already weakened decision. The notification by the government confirms that CSR is a state within the meaning of Article 12. 21. Notification under Administrative Tribunals Act. The notification issued by the central government in 1986 under Article 14 of the Administrative Tribunals Act, 1985 served to shift the service disputes of the employees of CSR from the jurisdiction of the High Court to the administrative tribunals. 22. Conclusion. The matter was remitted back to the appropriate bench to be dealt with in the light of the decision that CSR is a state within the meaning of Article 12 of the Constitution. This is a 7-judge constitutional bench judgment which is extremely important for a law student who aspires to learn about the journey of the established law and interpretation regarding Article 12 of the Indian Constitution. The chronological series of the cases one must follow to understand the true interpretation of Article 12 are: 1. Subhajit Tweri v. Roy 1975. 2. Sukhdev Singh and others v. Roy 1975. 3. Ramana Dayaram Shetty v. The International Airport Authority of India Air 1979. 4. A.J. Hasia v. Khalid Mujib Sarabardi Air 1981. 5. Pradeep Kumar Biswas v. Indian Institute of Chemical Biology. 6. Basi Reddy v. International Crops Research Institute Air 2003. Among the following mentioned cases, the cases which are a must-read are the Ramana Dayaram Shetty case, A.J. Hasia case, Pradeep Kumar Biswas case which is a must, and at last G. Basi Reddy. Usually students remain confused as to which cases should be read in order to understand Article 12. My attempt is to help you with that confusion. Summary of these landmark judgments is already provided on this blog, however it is in your best interest to read the whole judgment. What you need to know before this case: Sukhdev Singh case and the Subhajit Tweri were the cases that were decided on the same day by the same bench. In Subhajit Tweri the court held CSR not to be covered under Article 12, because of the reason that its origin or genesis was not from any statute. This indicta of the Subhajit Tweri case was followed in various other cases since it was 5-judge constitutional bench judgment which was to be followed by small benches. However, soon enough, the judgment started to gain criticism. Drastic changes started coming in the proposition of Subhajit Tweri's judgment, starting from Ramana Dayaram Shetty case and then A.J. Hasia case also indicated that statutory genesis is not the basis of the test. In the A.J. Hasia judgment held a regional college, which was not a statutory body but a society registered under Society Registration Act, to be a state under Article 12 of the Constitution. Finally, in the present case, by a 7-judge bench, the Subhajit Tweri was overruled. The settled law in this case was then followed in other cases in full length, one of the cases being G. Basi Reddy v. International Crops Research Institute, although the institute being international was not observed to have any dominance of the Indian government and was held not to be a state. Facts: the appellants filed a writ petition before the Calcutta High Court to challenge the termination of their services by Indian Institute of Chemical Biology, which is a unit of the Council of Scientific and Industrial Research. Remember the word CSR here, very important to get a hold of this body in the related cases. The writ was rejected by the High Court because of the decision taken in an earlier case, Subhajit Tweri case, in which CSR was held not to be an authority under Article 12. The case went to the Supreme Court and the 2-judge bench referred the matter to a larger 7-judge constitutional bench. This summary is of that 7-judge constitutional bench in which Subhajit Tweri's case was reconsidered. Issue 1. Whether CSR was a state within the meaning of Article 12. 2. And if yes, whether the Supreme Court should reverse the decision in Subhajit Tweri. Law 1. After reviewing all the previous cases, Sukhdev, Subhajit Tweri, Ramana, A.J. Hasia, the court in the present case concluded, with regard to the test for finding out whether a body is a state or any other authority under Article 12, the question in each would be, whether in the light of the cumulative facts as established, the body is financially, functionally and administratively dominated by or under the control of the government. Such control must be particular to the body in question and must be pervasive. If this is found, then the body is a state within Article 12. On the other hand, when the control is merely regulatory, whether under statute or otherwise, it would not serve to make the body a state. 2. The court also observed that the tests formulated in A.J. Hasia case were not rigid set of principles, and it all comes down to the facts of each case and then the test which is mentioned in the previous point. Financial. 2. Functional. 3. Administrative domination by the government. Important observations. The court observed the following points with respect to CSR, which established that CSR was financially, functionally and administratively dominated by the government, and such control was deep and pervasive. The court observed that 1. CSR was created by the government to carry on in an organized manner what was being done earlier by the Department of Commerce of the central government. 2. CSR was set up in the national interest to further the economic welfare of the society by fostering planned industrial development in the country. 3. All CSR's income and property was to be applied only towards the promotion of the objects as mentioned in CSR's memorandum, with the limitations on expenditure which would be imposed by the government. 4. The Director General, who is ex officio Secretary of the Society, was to be appointed by the Government of India. Furthermore, the members of the governing body who are not their ex officio are nominated by the President, and their membership could be terminated by him, and the Prime Minister is the ex officio President of CSR. 5. The governing body also has the power to frame, amend or appeal or repeal the bylaws of CSR, but only with the sanction of the Government of India. 6. Under bylaws, various service rules and orders, pay scale and reservation rules applicable to the government servants are applicable to the employees of CSR. 7. CSR could not lay down or change the terms and conditions of service of its employees, and any change in the bylaws could be carried out only with the approval of the Government of India. 8. The then financial position of CSR was that at least 70% of the funds of CSR were available from grants made by the Government of India. The court observed that the assets and funds of CSR, though nominally owned by the society, are in the ultimate analysis owned by the government. Held. 1. The court held that the subhajitwari decision must be overruled. 2. The court also held CSR to be under Article 12, and therefore writ petition was maintainable against the concerned body, in this case, Indian Institute of Chemical Biology, which was a unit of CSR. Did you know that the case of Pradeep Kumar Biswas v. Indian Institute of Chemical Biology set a significant precedent in Indian law regarding intellectual property rights and the protection of scientific research? The case of Pradeep Kumar Biswas and Ors v. Indian Institute of Chemical Biology and Ors is a landmark judgment that has had a profound impact on the realm of intellectual property rights and academic freedom in India. This case has far-reaching implications for scientists, researchers, and institutions engaged in scientific research, and it's essential to understand the facts and the legal implications of this case. In this video, we'll delve into the details of the case, exploring the narrative of the events that led to the lawsuit, the conflicts faced by the plaintiffs, and the court's ruling, which has had a lasting impact on the landscape of academic research and intellectual property in India. So, let's begin by introducing the key players involved in the case. The Indian Institute of Chemical Biology is a premier research institution in India, and it's where the events of this case unfolded. The plaintiffs, Pradeep Kumar Biswas and others, were scientists working at the institution, and their research was at the center of the controversy. The Indian Institute of Chemical Biology was established in 1935 as a pioneering research institution in India, focusing on chemical biology and its applications. Over the years, the institution has made significant contributions to scientific research in India, and it's considered one of the top research institutions in the country. In the early 2000s, the institution was at the forefront of scientific research in India, and it was during this period that the events of this case took place. The plaintiffs, Pradeep Kumar Biswas and others, were scientists working on a research project at the institution, and their work was gaining recognition both nationally and internationally. As the researchers continued their work, they began to realize that their research was being used without their knowledge or permission. This led to a major controversy, with the researchers accusing the institution of misappropriating their work and violating their intellectual property rights. The researchers claimed that they had developed a novel methodology during their research, and this methodology was being used by the institution without their consent. They alleged that the institution had breached their trust and had misused their research for commercial gain. The institution, on the other hand, claimed that the research was funded by them, and therefore, they owned the intellectual property rights to the research. They argued that the researchers were merely employees of the institution, and they had no right to claim ownership of the research. As the dispute escalated, the researchers decided to take the institution to court, alleging that their intellectual property rights had been violated. This marked the beginning of a long and complex legal battle that would have far-reaching implications for the scientific community in India. The court case was a complex one, with both sides presenting strong arguments. The researchers argued that they had developed a novel methodology, and therefore, they owned the intellectual property rights to it. They claimed that the institution had failed to protect their rights and had instead misused their research for commercial gain. The institution, on the other hand, argued that they had funded the research, and therefore, they owned the intellectual property rights to it. They claimed that the researchers were merely employees of the institution, and they had no right to claim ownership of the research. The court considered the arguments presented by both sides and eventually ruled in favor of the researchers. The court held that the researchers owned the intellectual property rights to the novel methodology, and the institution had breached their trust by misusing their research. The court's ruling had significant implications for the scientific community in India. It established the principle that researchers have the right to claim ownership of their research, even if it's funded by an institution. This ruling has far-reaching implications for scientific research in India, as it ensures that researchers are protected from exploitation by institutions. The ruling also has implications for institutions that fund research. It establishes the principle that institutions have a fiduciary duty to protect the intellectual property rights of their researchers. This ruling has ensured that institutions are more transparent and accountable in their dealings with researchers. The case of Pradeep Kumar Biswas and Ors v. Indian Institute of Chemical Biology and Ors is a landmark judgment that has had a lasting impact on the landscape of academic research and intellectual property in India. It has established the principle that researchers have the right to claim ownership of their research, and institutions have a fiduciary duty to protect the intellectual property rights of their researchers. In conclusion, this case is a significant milestone in Indian law regarding intellectual property rights and the protection of scientific research. It has far-reaching implications for the scientific community in India and has ensured that researchers are protected from exploitation by institutions. If you're interested in learning more about this case and its implications, I encourage you to do some further research. Share your thoughts in the comments below, and let's continue the discussion. Also, be sure to check out our other videos on similar legal cases and their impacts on the scientific community. Thanks for watching.